I came to the police station in 2003 and told the officers I was innocent. They didn't believe me. I came to the Crown Court in Manchester in 2004 and told the jury I was innocent. They didn't believe me. I came to this appeal court in 2006 and told them I was innocent. They didn't believe me. I applied to the Criminal Cases Review Commission, which is supposed to investigate miscarriages of justice, and told them I was innocent. They didn't investigate, and they didn't believe me. Not once, but twice. Today we told this court I was innocent, and finally they listened. But I have been innocent all along, for each of those 20 years that came before today. Nothing any police officer, court, or commission said about me since 2003 changed that reality. You are here to gather news. That declaration from the bench in there behind me is not news to me. When a jury finds you guilty when you are innocent, reality does not change. You know you did not commit the crime. But all the people around you start living in a false fantasy universe and treat you as if you are guilty. The police, prison officers, probation, prisoners, journalists, judges. As a minority of one, you are forced to live their false fantasy.
Imagine waking up in a coffin, 6 feet underground. You scream, you claw at the wood, but no one hears you. You are trapped, buried alive. And the worst part, you didn't do anything to deserve it. For far too many people in prison, this isn't just a nightmare, it's their reality. They're serving time for crimes they swear they did not commit. But here is the catch. Claiming innocence has long been a reason to deny parole. For years, maintaining innocence meant one thing: you are in denial. You are not showing remorse. And without remorse, no parole. For years, the justice system has treated those who insist they did not commit a crime with skepticism, often framing their refusal to admit guilt as a psychological barrier rather than a legitimate stance. But what if they're telling the truth? What if their so-called denial is not a defense mechanism, but a firm stand against a wrongful conviction? In this video, we will explore whether the perception of maintaining innocence has in any way shifted, why it has historically been a roadblock to parole, and what recent policy changes mean to those still fighting to prove they were wrongly convicted. Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Before we begin, a quick reminder to hit that subscribe button to support us in delivering a unique perspective on our justice system, its functions, its flaws, and the changes it desperately needs. Our goal is to spark conversations and explore meaningful reforms to ensure the system serves people, not just rules. Your likes and shares help us push this mission forward. And of course, don't forget to comment. Your thoughts are where the real sparks fly, shaping the conversation and driving change. So let's embark on this journey to explore the fine line between denial and maintaining innocence. Let's start with the basics, as we always do. Article 6 of the Human Rights Act states that everyone charged with a criminal offence shall be presumed innocent. But here is the crucial part. This presumption of innocence does not last forever. The moment a jury delivers a guilty verdict or a judge finds you guilty, the legal system no longer sees you as someone who might be innocent. Instead, you are now officially and unquestionably guilty in the eyes of the law. From this point on, the burden shifts entirely. No matter how strong you insist in your innocence, the system treats you as if the case is closed, and proving otherwise becomes an uphill battle. While admitting guilt comes with benefits, maintaining innocence often comes at a heavy price. Those who refuse to confess because they genuinely did not commit the crime are not only denied sentencing discounts, but they may also face harsher penalties, prolonged imprisonment, and obstacles to parole. In essence, the system penalizes individuals not for what they've done, but for standing by the truth. It creates a paradox where honesty and integrity can become barriers to freedom, forcing the innocent into an impossible dilemma: falsely confess for a chance at release, or maintain innocence and risk being trapped in the system indefinitely. As we saw at the beginning of this video, Andy Markinson described his experience as if he were trapped in a false fantasy universe where everyone but him believed he was in denial. The parole board hurdle applies to all defendants serving any type of prison sentence once they become eligible for early release. Note, I intentionally refer to them as defendants rather than offenders, as maintaining innocence means they do not fit the definition of an offender. However, I acknowledge that in parole terminology, the standard term used is offenders. So as I was saying, the hurdle applies to all defendants. However, it is particularly pressing for specific categories of defendants, namely indeterminate sentences, ISPs. These are individuals serving sentences where no fixed release date is set. The prisoners must demonstrate to the parole board that they no longer pose a risk to the public before they can be released. There are two main types of ISPs in the UK: indeterminate sentences for public protection and life sentences. Indeterminate sentences for public protection include imprisonment for public protection, or IPP, applied to over 18, and detention for public protection, or DPP, applied for under 18s. IPPs and DPPs were introduced in 2005 under the Criminal Justice Act 2003. These sentences were meant for offenders deemed dangerous but whose crimes did not warrant a life sentence. The offender was given a minimum tariff, after which they had to prove to parole that they were no longer a danger to society. Although IPPs and DPPs were abolished in 2012, the reform was not applied retrospectively. 8,711 IPPs and DPPs were imposed between 2005 and 2012. There has been lots of controversy about this type of sentences, and recent changes have been implemented which perhaps warrant a dedicated video on its own right. But as well as IPPs and DPPs, then there are the life sentences. These are prisoners serving mandatory or discretionary life sentences. They must serve a minimum tariff before being eligible for parole. IPP prisoners and life sentence prisoners will remain on life license even after their release, meaning that they can be recalled to prison if they breach the conditions of their release. As we said in our introduction, for years the justice system has treated those who insist they did not commit a crime with skepticism, often framing their refusal to admit guilt as a psychological barrier rather than a legitimate stance. This, however, has been challenged on several occasions and successfully challenged. The leading case is that of the Regina and Parole Board and Secretary of State, ex parte Oyston, which was decided in 2000. Mr. Oyston was convicted and sentenced to 6 years in prison for 2 counts of rape. He consistently maintained his innocence both during and after his trial. Although the Parole Board recognized his good behavior and participation in a rehabilitation course, it denied his early release because he refused to accept responsibility for his offences. He challenged this decision through judicial review and won, but the Parole Board appealed. However, the Court of Appeal rejected the Parole Board's appeal, ruling that its refusal was clearly based on Mr. Oyston's failure to admit guilt, which is unlawful. It was a point accepted by the Parole Board that it is unlawful for the board to deny parole solely on the ground that the defendant continues to deny his guilt. The board's first duty is to assess the risk to the public that the prisoner might commit further offences if he is paroled. In making this assessment, the Parole Board must assume the correctness of any conviction, and it can give no credence to the prisoner's denial. The test that the Parole Board should apply is as to the current level of the risk to the public, and it is essential in applying that test that all the circumstances of that particular case are considered. In this case, his previous good character, positive behavior in prison, commitment to changing his lifestyle, and strong family support all indicated a low risk to the public, supporting the case for early release. Although the official stance was that it was unlawful for the Parole Board to deny parole solely because a prisoner refused to admit guilt, the fundamental issue remained. There was no acknowledgement that someone maintaining innocence might not be in denial, but rather genuinely did not commit the offence. A turning point was reached in 2010 with the amendment of the Prison Service Order PSO 4700, which for the first time recognized that some prisoners maintaining innocence may actually be innocent. Paragraph 4.14.1, amongst the reasons as to why an offender may maintain innocence, states they may actually be innocent. Some prisoners have been found not guilty following a retrial, sometimes many years after the original conviction. And at paragraph 4.14.3, processes exist for the ISP to challenge the safety of the conviction, for example, through the Court of Appeal or the Criminal Cases Review Commission. It is for the courts and the Independent Criminal Cases Review Commission to review alleged miscarriages of justice in England, Wales and Northern Ireland, and prisoners should be advised to take legal advice, follow legal appeal process, and should they fail on appeal and continue to maintain their innocence, to contact the Commission. We understand that this change was largely attributed to Dr. Norton and his dedicated efforts in addressing innocence claims. He played a pivotal role in establishing a network of Innocence projects across the UK through the Innocence Network UK, INUK, which he founded at the University of Bristol in 2004. By June 2013, this network had expanded to include 26 projects. Unfortunately, the INUK stopped operating in 2014. Since 2008, Dr. Norton had significantly influenced the treatment of prisoners maintaining innocence by sharing his research with policymakers, including the Parole Board and the National Offender Management Service, the NOMS. His efforts led to a shift in how such prisoners were perceived, with NOMS and the Parole Board acknowledging that some may genuinely be innocent rather than simply being in denial. His research played a key role in developing new assessment methods for these prisoners and influenced the design of a new management intermediate sentences and risk training course, which had been delivered to around 30,000 prison and probation officers across the UK. This course educated staff on why prisoners might claim innocence and trained them to provide information about the appeal system and relevant support organizations. However, despite this acknowledgement, no practical changes were in fact implemented, and only a small number of prisoners who maintained their innocence had been released. One example is Susan May, who was accused of murdering her aunt in 1992, but continued to protest her innocence until she died of cancer aged 68. This is an article from the Prison UK blog, An Insider's View, published on the 30th of July 2014. Since 1st of November 2013, the new incentive and earned privilege IEP system via Prison Service Instruction 30/2013 has made it much harder for prisoners who are claiming to be victims of miscarriages of justice to reach or maintain their enhanced level of privileges. I know a number of inmates who have recently been demoted to standard level and have had much of the personal property that they have previously purchased, such as DVD players or musical instruments, confiscated. Some are now facing an uphill struggle to even stay on standard level. The alternative is life on the highly punitive basic regime. This can involve effective solitary confinement for up to 20 days a day, 7 days a week, in addition to no personal clothing, no rented TV, hardly any possessions, virtually no access to money to buy telephone credits or stamps, limited opportunities to exercise, to phone family, or even taking a shower. Enduring that sort of social mental deprivation and draconian punishment for months or even years takes a grim determination to maintain your innocence or a very strong moral character. Mental deterioration for such prisoners is a real risk. By contrast, this is what the head of Sentence Management Group wrote on the Prison Service Journal, issue 143, in 2002. It starts by stating, there have been a number of inaccurate articles in the press claiming that if lifers do not admit their guilt for the offence they've been convicted, they will remain in prison literally for life. This article seeks to set the record straight, but then it concludes the prison service accepts the general presumption that the conviction was correct, does not meet the case of the person who is genuinely innocent. and who has exhausted all avenues of appeal without success. But the key issue affecting a lifer progress and ultimately release is whether their level of risk, irrespective of their denial, has reduced. Quite frankly, we fail to see how risk can be reduced when it was never there to begin with. Mr. Markinson provided us with a detailed account of his treatment. Let's hear what he had to say about his parole meetings.
At every parole hearing, I sat before a panel who shook their heads at me, considering me to be dangerous. And all that time, the real perpetrator, the real dangerous person, was free. More recently, I was allowed to leave prison, but with my name on the sex offenders register and under tight supervision by police and probation, I was not free. Told every day that I was a liar, I sought the uncomplicated truths of science and mathematics through the Open University. Told every day that I was a violent monster, I sought tiny respites through Buddhism and meditation. Told that I was in denial about my offending behaviour. I read everything I could about a justice system that was in denial about its mistakes. Since I was arrested in 2003, the police, the prison system and probation service have been calling me a liar because I denied that I committed the crime. They claimed I was in denial and made me serve an extra 10 more years in prison because I would not make a false confession. I am not a liar. I am not in denial.
On the 26th of July 2024, exactly 1 year to the day since Mr. Markinson's conviction was overturned, the Parole Board issued a new guidance. The guidance was published by the Parole Board on the 30th of August 2024. Under the announcement under section Details, it states, this guidance provides information, research outcomes, and practical advice for parole board panels when presented with a prisoner who maintains their innocence. It offers support to panels through the member case assessment (MCA) stage, through oral hearings, and when writing decisions. It aims to offer support to panels when assessing risk in cases where a prisoner maintains their innocence. It will set out the relevance and weight to attach to denial of guilt and other interlinking factors. So let's take a look at the guidance. Looking at the executive summary, we note the position has not changed. The board's starting point is that the prisoner was rightly convicted and is therefore guilty of the offence for which they've been convicted. It is unlawful for panels to refuse a release solely because a prisoner maintains innocence, without considering how this will affect risk. And it continues, the board's role is not to reconsider guilt or validate denial, but to assess risk and determine whether the test for release has been met. While a denial of guilt can be a significant factor in certain cases, it should not automatically count against release or move to open conditions. It then goes on to state that understanding the type and level of denial and the reasons behind someone maintaining their innocence can help in assessing risk. It distinguishes between complete and partial denial and lists several possible motivations for maintaining innocence, including shame and guilt, threats to relationships and image, and fear of consequences. Yet glaringly absent from this list is the most obvious reason that the person might actually be innocent. A step back, it seems, from the Prison Service Order 4700. However, Inside Time offers insight into how this guidance differs from previous version and sees it as an improvement. The parole board has said that the prisoners who maintain their innocence do not necessarily pose a higher risk to the public and in some cases may be less likely to reoffend. At page 7, paragraph 3.1, the guidance states, "There is often a misconception that those who maintain their innocence must pose a higher risk of harm. Whilst in some cases it can be an indicator of higher risk, such as where the prisoner has not completed work that could evidence a lower risk, in other cases, it may not impact upon the assessment of risk, or indeed potentially be a protective factor." It has been argued in the desistance literature that maintenance of innocence can be protective of self-identity and reduce stigma and shame. People are more likely to desist when they have strong ties to family and community, employment that fulfills them, recognition of their worth from others, feeling of hope and self-efficacy, and a sense of meaning and purpose in their lives. These may be easier to achieve if someone maintains their innocence. Going back to the Inside Time article, it adds, "A spokesperson for the campaign group Progressing Prisoners Maintaining Innocence said, 'We welcome this guidance document.' It does not mention that one reason prisoners may maintain innocence is because they are factually innocent. And of course, this can be a significant factor making future offending less likely. However, the guidance does offer multiple reasons why maintaining innocence can be a protective factor. The broader approach it mentioned regarding risk assessment is encouraging, examples being engagement with the risk process, an exemplary prison record, and no previous offences. We remain skeptical. As a fundamental flaw in all these guidances seem to be the interchangeable use of denial and maintaining innocence, which is explicitly stated in paragraph 1.1 of the guidance. This mix, in our view, undermines any genuine attempt to fairly assess prisoners who insist they were wrongly convicted. The assessment process itself seems almost surreal. It is as baffling as the letter of the Ministry of Justice refusing Brian Buckle's compensation, stating in one paragraph, "I do not consider that the effect of the newly discovered fact in your case demonstrates beyond reasonable doubt that you did not commit the offence for which you were convicted, yet in the very next you are presumed to be and remain innocent of the charges brought against you." The contradiction in this guidance exposes a deeply flawed system, one that persistently views prisoners maintaining innocence with suspicion, despite acknowledging the reality of wrongful convictions. The very existence of the Criminal Cases Review Commission, established to uncover such miscarriages of justice, is proof that wrongful convictions do occur and that the system believes that they occur. The interchangeable use of denial and maintaining innocence is not just a semantic issue. It has real consequences. It forces wrongly convicted individuals into an impossible situation. Either falsely admit guilt to satisfy parole conditions or maintain their innocence and remain indefinitely imprisoned. While the guidance claims to take a broader approach to risk assessment, it ultimately fails to address the core injustice, that those who insist on their innocence are still being evaluated through a framework designed for the guilty. This is not just an oversight, it is a fundamental betrayal of justice. Imagine losing years, decades of your life for a crime you did not commit. Imagine sitting in a parole hearing where you are expected to explain your risk factors for reoffending when you have never offended. Imagine being told that you must engage in therapy for a crime you are innocent of or remain locked away indefinitely. This isn't hypothetical.
Since I was arrested in 2003, the police, the prison system and probation service have been calling me a liar and made me serve an extra 10 more years in prison.
This is the reality to countless prisoners in the UK today. Indeed, the guidance itself acknowledges that in some cases, maintaining innocence can be an indicator of higher risk, such as where the prisoner has not completed work that could evidence a lower risk. How this is implemented in practice remains unclear. Justice should not depend on whether an individual is willing to lie to regain their freedom. A system that punishes truth and rewards false confession is a broken system. And until this fundamental issue is addressed, no amount of new guidance or policy tweaks will make a difference. The question we must ask is simple. How many more lives must be destroyed before real change happens? And what do you think? Are prisoners who maintain their innocence in a better position today? Share your thoughts in the comments below. I'd love to hear your views. If you found this video insightful, don't forget to like and share to help spread awareness. And if you haven't already, subscribe to support the growth of this channel and help us reach more people. Together we are stronger. Join us again as we sit and rise in this unique trial.